All right, good afternoon, everybody. We're going to go ahead and get started. We've got a full agenda today. There's both a special exception matter to be heard. It'll be heard first, and then we have two code enforcement matters. So if you're here on either code enforcement matter, you are in the correct place, but we're going to handle the items in the order they are on the agenda. And so the first one will be the special exception hearing, and then we'll go into the code enforcement matters. Welcome to the City of Madeira Beach Variance or Special Exception Use Special Magistrate Hearing. My name is Bart Valdez, and I am the appointed Special Magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth under Florida law and the City of Madeira Beach Code of Ordinances. It is my role to fairly and objectively review the matters presented today in these requests. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. At this time, I have read and reviewed the applications with all attachments, any written submissions by anyone having an interest, any timely submitted written objections, and the materials provided by the city staff. In all cases, the hearing will be conducted in the following order. We will confirm public notice has been proper. The city will present its case and staff report, and the applicant may ask questions of the city's representative. Number 3, the applicant will present his or her case supported by any witnesses and evidence, and the city may cross-examine each witness. Number 4, we will accept public comment from parties directly affected by the variance. Individuals testifying do not have the right to cross-examine the parties. In order to provide everyone an opportunity to provide public comment, all public comment shall be limited to 3 minutes per person. Public participation will then be closed. I'll deliberate and then make a decision to grant or deny each request in the application. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After my decision today, I will issue an order. The order will be reduced to writing, and the applicant will be provided with a copy by mail. Additionally, you are advised that I do not have the authority to grant you a building permit. You must still obtain a building permit for any work you intend to do on your property. If you wish to present any information to me today, whether you're an applicant, a witness, or a member of the public, it is necessary that you swear or affirm that you will tell the truth. Therefore, in just a moment, the city attorney will administer the oath and swear in all witnesses. If you expect to talk to me today during the hearing on this special exception, then you need to rise and be sworn. This includes any members of the public who are directly affected by the request and may wish to provide public comment. So if you plan to testify in regard to the special exception matter today, please rise and Mr. Trask will swear you in.
You could raise your right hand and be sworn under oath. Swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? Thank you.
All right, the first matter that I have on the agenda is SE 2023-01. Mr. Trask, is the city ready to proceed?
Yes, we are.
Go ahead.
Okay. We're going to have Mr. Andrews Morris testify today on this particular matter. Mr. Morris, if you could explain to the special magistrate your job responsibilities and your occupation here at the city.
Hi, my name's Andrew Morris. I'm a long-range planner in the Community Development Department. One of the tasks outside is dealing with stuff like the comprehensive plan and various ordinances. I handle variances and special exception uses.
All right. Can you bring the microphone closer to your face, please? Thank you.
No problem.
So are you familiar with this particular application today, the special exception application 2023-01?
Yes, sir.
Did you prepare a staff report and recommendation?
Yes, sir.
Okay. Could you go through your staff report for the special magistrate?
Okay. The request is the approval of SE 2023-01 to allow a standalone parking lot as a principal use pursuant to Section 110-259-6 upon compliance with other requirements of the Madeira Beach Code of Ordinances related to off-street parking areas. This specific code provision is Division 5, C1 Tourist Commercial, Section 110-259, Special Exception Uses, standalone parking lots and parking garages as a principal use. Background. The applicant, UPP Global LLC, is applying for a special exception use to operate a standalone parking lot. The property is in the C1 Tourist Commercial Zoning District and has a future land use of commercial general. a parking lot as a primary use of the property is allowed special exception use in the C1 zoning district. Next is the criteria for special exception use. The first one is that the use is a permitted special use. And findings in the Madeira Beach Code ordinances, Division 5, C1, tourist commercial, Section 110-259, special exception uses. 6, allows for a standalone parking lot to be a permitted use with the approval of a special exception use by the special magistrate. 2, that the use is so designed, located, and proposed to be operated that the public health, safety, welfare, and convenience will be protected. In findings, the C1 Tourist Commercial Zoning District has commercial establishments focused on tourism and some temporary lodging dwelling units. A parking lot would not negatively impact public health, safety, welfare, and convenience. The applicant would be required to bring the parking lot into compliance with drainage requirements in Chapter 998, Natural Resources. 3, that the use will not cause substantial injury to the value of other property in the neighborhood where it is to be located. Most of the nearby properties are commercial uses and they are oriented towards tourism. A standalone parking lot as a primary use of the property would not hurt the value of other nearby properties. Many of the nearby properties have limited space for off-street parking. A standalone parking lot would help create additional off-street parking opportunities for customers using nearby businesses. 4, that the use will be compatible with adjoining development and the proposed character of the district where it is located. Nearby properties are commercial uses and oriented towards tourism. A standalone parking lot would be compatible with the adjoining development and fit the character of the C1 zoning district. 5, that adequate landscaping and screening is provided as required in land development regulations or otherwise required. The property owner will be required to bring the parking lot into compliance with the off-street parking requirements located in Chapter 110 zoning, Article 7, off-street parking and loading, and landscaping requirements in Chapter 106 vegetation, Article 2, landscaping. 6, that the adequate off-street parking and loading is provided and ingress and egress is so designed as to cause minimum interference of traffic on abutting streets. Findings. Primary use of property would be for off-street parking. The parking lot must meet the driveway requirements in Chapter 58, streets, sidewalks, and other public places, Article 2, sidewalks and driveways. 7, that the use conforms with all applicable regulations governing the district where located except as may otherwise be allowable for planned unit developments. Under findings, the proposed special exception use would conform with all applicable regulations governing the C1 zoning district. The applicants will be required to bring the parking lot into compliance with all of the applicable requirements for off-street parking areas and landscaping. 8, if a variance is also desired and/or required, a separate application shall be submitted concurrently with the special exception application. Under findings, an additional variance would not be needed for the proposed special exception use. Standalone parking as a primary use of a property in the C1 zoning district is allowed with an approved special exception use without needing an additional variance. Under 9, special exception use will not grant the land more privilege than the best use available in a zone where the special exception use would be a principal permitted use. Findings. Any property within the C1 Tourist Commercial Zoning District can apply for a special exception use to allow for a standalone parking lot as a principal permitted use of the property. Granting a special exception use would not grant the land more privilege than the best use available in a zone where the proposed special exception use would be a principal permitted use. 10, no application for a special exception use shall be considered by the special magistrate until the applicant has paid in full any outstanding charges, fees, interest, fines, or penalties owed to the city by the applicant or the owner or possessor of the property under any section of the code. Under findings, there is currently an open code violation case for use and failure to comply with off-street parking requirements. No fines have been levied because the applicant is in the process of resolving the code violation. The applicant must receive approval of a special exception use to resolve the outstanding code violation, and then the applicant would be able to apply for a building permit to bring the parking lot into compliance. On the last part of The report is staff recommendations. Staff recommends approval of SE 2023-01, subject to the following conditions. The first one, the standalone parking lot must be brought into compliance with off-street parking requirements located in Chapter 110 zoning, Article 7, off-street parking and loading. The parking lot must meet the landscaping requirements located in Chapter 106, vegetation, Article 2, landscaping, the special exception. The standalone parking lot must adhere to the drainage requirements in Chapter 98, natural resources. The standalone parking lot must meet the driveway requirements in Chapter 58, streets, sidewalks, and other public places, Article 2, sidewalks and driveways, and then an approved building permit will be required to bring the parking lot into compliance. And attached to it are the application and attachments and the public notice and the mailing and list and the posting pictures of where it was posted.
A few more questions then, Mr. Morris. Has the city received any correspondence with regard to this application? Anyone in opposition or in favor of this application?
We haven't received any emails related to this item or any notice of intents.
Okay, so no one has stepped forward then and claimed that they're an affected party to receive notice, correct?
Correct. I and Lisa and our department haven't received any.
Okay, and do you wish to tender into evidence your staff report, which would be pages 3 through 27?
Yes.
All right, I'll go ahead, and I think it starts on, page 3, shaded page 3 through shaded page 27. I'll accept that in as exhibit number 1.
Thank you. I have no other questions for Mr. Morris.
All right, is anyone here on behalf of the applicant, UPP Global? Come on forward, sir. All right, this is the part of the proceeding where you can ask any questions you want of Mr. Morris. As you heard, staff is recommending approval subject to 5 conditions. I'm going to give you in just a moment an opportunity to come up and tell me anything else you want to tell me, present your case, whatever you want to do. But at this point in time, this is your opportunity to ask questions of Mr. Morris, to cross-examine him. Do you have any questions for Mr. Morris?
We have no questions.
All right, thank you. Have a seat. Mr. Trask, any other witnesses?
We have no other witnesses. Thank you.
All right. Sir, come on back forward. And I understand you're here on behalf of UPP Global LLC, is that correct?
Yes, and
And give me your full name and address,
so my
please.
name is Scott Brainerd, 101 150th Avenue, Madeira Beach, Florida, 33708.
Tell me how you spell your last name.
Brainard.
All right, Mr. Brainerd, what would you like to tell me about this application?
Well, we agree 100% with the staff recommendation. This property has been used, portions of the property have been used for decades as a public parking lot. Since 2014, all but 2 lots in all but 3 lots have been used as a public parking lot. When the current owner purchased the property in 2021, there was an existing building on one of the lots that was no longer usable for retail. It was torn down and converted into parking. The general area of Johns Pass Village is heavily commercialized with very little on-site parking for any of the tenants. And so the need for parking is huge for the entire entertainment district there. Without the parking lot here, I think that there would have some major adverse impact on the value of businesses and properties in the area. I say this property's been used as a parking lot for decades, and we realize that it doesn't meet the requirements of the code at this point. Nobody's ever made a request for it to be improved. So we certainly don't have a problem with improving it and meeting all the requirements of the code, whether it be the construction or drainage or landscaping. So From our perspective, this is something that's needed by the community. It's been used by the community. We'd like to be able to continue, and if we need to do some additional improvements on the property in order to get a special exception for this use, we're happy to do that.
All right, sir. Mr. Trask, do you have any questions of the applicant?
Mr. Brainerd, yeah, your client is in agreement with all the recommendations of city staff, correct?
Yes.
Okay. And just, Mr. Valdez, just so they know, Mr. Brainerd is an attorney.
Okay.
Okay, all right, thank you.
Okay.
All right. Mr. Brainerd, anything else you'd like to share with any of the witnesses you want to call or anything like that before I open it up to public comment?
I have people here that will make public comment if there is other public comment, but other than that, we don't need to provide any witnesses.
All right. Sounds good, sir. Thank you. All right. At this point in time, we'll go ahead and open it up to public comment. Is there anyone, any member of the public that would like to come up and comment on special exception application 2023-01? All right, going once. Okay, we got somebody who wants to come up. Oh, I'm sorry, come on up. And if you could, when you come up here, you speak into the microphone for the record. And the first thing is if you can please give me your name and also spell it.
Sure. Stephanie Berry, last name is Berry. I have the business at 205 Boardwalk Place East, right across the street from the parking lot. My father owns the business. We run two businesses in there, the one that has Boardwalk Grill right upstairs from us. So first and foremost, I'm all in favor of getting it cleaned up. Like, we need parking in John's Pass desperately. I've attended dozens and dozens of meetings through John's Pass in Madeira Beach, and I believe that this will only help just the overall aesthetic piece of John's Pass. There's only two things that I would ask out of it, is that the Boardwalk Place East, during any type of construction, not be shut down during that time frame, as during busy season and in off-season, we need that for service vehicles to go up and down in order to do our business on a daily basis. And then the second thing that I would ask is for the parking, FL Parking Company, which is the company that is running the lot, to land on a price. Right now, we've got the city of Madeira Beach that's at $3 per hour with a maximum of $60 ticket. Got the parking garage at $6 an hour, where it's a minimum of 2 hours. And over the course, since we received the notification of since last Thursday, we saw the parking price go from $25 to $35 to $38, to then one area of the lot being $8 per hour, and then the other area being $30 per hour. I will do everything I can to promote my business as well as to promote the parking lot, but I can't tell my customers what the price is, because it's changing on an hourly basis based on however the flow, whether it's because there's more traffic, whether there's more customers. I'm not exactly sure what the reasoning is for all the different prices, but that's all I ask, is that for us to land on a price, you can get it posted so everyone feels good about it. And that's it. Thank you.
Thank you for your comments, Ms. Berry. Any other member of the public? Come on forward, sir. And again, just like Ms. Berry did and just like Mr. Brainerd did, if you can please give me your full name and spell your name.
William Carnes, Karns, 101 150th Avenue, Madeira Beach, Florida. I'm one of the owners of the property over there. I just wanted to address Ms. Berry, that we lease out that property to UPP. Their parking rates vary depending on the type of, time of the year. Spring break was obviously the highest demand, and prices were a little bit higher there. I think Dan McNutt could address and talk about how they have their rates done, but they've been parking that lot for, well, Dan's been leasing there for almost 7 years now. It was parked on that before. It's always been a parking area for the businesses in the past. We own multiple businesses along the pass ourselves, and our customers pay to park there just like Ms. Berry's customers would pay to park there. So it is a business, and the business needs to have a positive cash flow in order to continue. So hope Dan can address that for you, but As I stated, it's been a parking lot for many years, and we just wish to continue to provide parking, not just for our businesses along the pass, but for all the businesses in the pass. Parking's a real problem in Johns Pass. Thank you.
Thank you, Mr. Carnes. And Ms. Trash, I think it's beyond the purview of what's before me today to deal with anything having to do with this.
I would agree. You don't have the ability to set the price of the parking lot.
Yeah, so I hear what the public is saying. This is not an issue that's before me today legally. It's not something I can decide on, but I'm happy to continue to hear public comment. Again, the issue is whether or not the special exception should be granted. But if anyone wants to come up, please, we have the opportunity. Come on up. Go up, sir, and then ma'am, we'll get to you next. Sir, what's your name?
Robert Bello, Bello, 13301 Gulf Lane. And
Sir, what would you like to tell me?
just that parking is definitely needed down there. This weekend, wanted DeLos's Pizza, 2 o'clock, they don't deliver, so had to drive down there. And even though I have a parking pass and should be able to park free, no parking. So without the lot there, wouldn't been able to, visit their establishment and purchase food. So I'm in favor of it.
Thank you, Mr. Bell. I appreciate that. Ma'am, I think you were making your way in the back. Come on forward.
Hi, I'm Sue Zerneski from Walt's Fish Shack. Walt and I have owned the property for 19 years.
Ma'am, spell your last name for me, please.
Zirneskie.
Neskie, gotcha.
The only thing I'm going to say is, first, obviously, we do not want to be shut down as well for the parking, and parking is needed. The one thing about the city, it's very clear that parking is only $3 an hour, which for 19 years, we have been around a fishing community and very family-oriented. There's people fishing right across from us all the time. And in season this past year, the parking was as high as $60. It's $40, $55, $60. And the people that are doing the Florida parking, unfortunately, are giving tickets on top of that. And the kids that are parking people are incentivized to give parking tickets. So from a business owner for 19 years, we have free parking at Walt's Fish Shack. So we don't have the same things, but unfortunately, because the parking is adjacent to the property, what happens is they come with their tickets every day and they say, well, I already paid $45, I already paid $60, and then they get a ticket for $63.13 on top of it. So from a tourist area, we just want people to be fair. But the two things that I have a question for the city staffer is, Walt is 100% disabled, and he couldn't walk in that parking lot if he wanted to. So is paving part of the procedure? Because I watch people struggle in wheelchairs every day in that parking lot. So I wanted to know, yes, you're trying to make it aesthetically pleasing to people, but I want to know, are you asking them to either blacktop it or pave it? And I didn't hear that mentioned, so I wanted to know about that. And then also, is there any way, we understand there's fluctuation in prices because people would say our business is super expensive, because I know that's what they're going to say, and fresh fish is expensive and we rely on, but our little business is totally marked every day and we always tell people fresh fish. So my question is twofold. A, do they have to pave the parking lot so that there isn't, because I watch people struggle all the time. And then secondly, could there be any stipulation for businesses that are right next to the parking lot? So when the D'Agostinos owned the building, what happened is Florida Parking gave the Hut and Scully's vouchers. So is there any way that you could give the voucher for Walt's Fish Shack next to that parking lot? We're talking many parking lots. So maybe for the jet ski rentals, they could, at that particular parking lot, receive a little less expensive tickets so we could promote that. Because we promote the city parking all the time. We're well aware it's really a good value for the city parking. But if the value of those parking lots could be a little bit more reasonable, I think it would be a value to all the businesses. I know we personally have lost some business based on the parking rates. People said they just can't come there, and they weren't aware that we had free parking. And then there's a lot of bars, and there's going to be future bars that are coming. And people aren't going to want to spend $20 and $30 to park and just go in and have a thing of chicken wings and a beer. So please consider that later. But I'm 100% for parking. That's not the question. But maybe one of the lots could be designated to work with the city, and you could share that parking lot and share the rates. Something to be considered for the businesses in John's Pass.
I appreciate that, ma'am. And again, some of these things are simply beyond the scope of authority I have, but I heard everything that you said. I understand what you said. You can talk to city staff afterwards about the conditions that are in the, what they're asking for, and they can answer that after the hearing on this.
Thank you.
Okay? All right. Another member of the public, come on up. Sir, give me your full name and spell it for me, please.
My name is Dan McNutt, DanMcNutt. I live at 8099 Bayshore Drive in Treasure Island. I'm the owner of UPP Global LLC, and our Florida operating entity is FL Parking Co. My corporate office is based in Portland, Maine. We've got about 420 locations in 9 states, stretching from Portland, Maine, down to Key West here in Florida. You know, one thing that I'd certainly be happy to do is spend time with, any of the local merchants and business owners in John's Pass and provide a little more education, I think, on some serious misconceptions about rates that are being mentioned that have never existed, that don't exist. We do, excuse me, for my business, we obviously do not want to price ourselves out of any market that we're in. We do practice dynamic pricing where we're catering to different user groups during different times of the day or different days of the week or different months of the year based on demand. Our goal is that we keep the parking lots full and that we're providing that convenience and service for folks. We also make parking programs available for local staff to create solutions for all the folks that are working in John's Pass as well, with significantly discounted all-day rates. And so, we are very focused on and constantly working on ways to be a good partner to the community. We look forward to completing the work, the scope of work that's been requested and becoming, compliant with the code.
Thank you, Mr. McNutt. I appreciate that. Is there anyone else who would like to speak on this issue? All right, come on forward, sir.
Hi, Jeff Beggins. I live at 429 Boca Ciega Drive.
All right, hold on. Jeff, spell your last name for me.
Beggins.
Okay.
429 Boca Ciega. I own the property right across from the lot in 209 Boardwalk and a partner in 215 Boardwalk. I just want to say that I think this is great. I think it's going to clean up the area and parking is very needed, so all favored, all support.
Thank you, sir. All right, is there anyone else who would like to come forward and speak on SE 2023-01? Okay, I'll go ahead and close public comment. Mr. Trask, is there anything else you'd like me to consider before I rule?
Nothing else. The staff recommendation is to approve with the conditions that were listed in the packet.
All right, I'm going to go ahead and based upon the staff report as well as the favorable public comment, I'm going to go ahead and grant the special exception 2023-01, subject to the 5 enumerated conditions. Mr. Brainerd, I'll get an order out to you, and it'll be coming to you in the mail. Ms. Berry, Ms. Zarneski, the person you need to talk to about your parking concerns is in the blue shirt back there. So you can talk right outside there. We're going to move on to the code enforcement matter. So if you like to leave for special exception, please feel free to leave. We're going to move into code enforcement now. You're also welcome to stick around if you want, but I don't think it'll be that exciting.
Thank you.
All right, good afternoon, everyone. We're now ready to move on to the code enforcement portion of today's hearing. Welcome to the City of Madeira Beach Code Enforcement Hearing. My name is Bart Valdez. I'm the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn by the city attorney in just a few moments. In all cases, the city has the burden of proof. The city will present its case first. The respondent or property owner then will be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine, and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, I ask that the city attorney swear in all witnesses.
Anyone that's going to speak, stand up, please. Be sworn under oath. You swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? I do. Okay, thank you.
All right, the first case on the agenda in code enforcement is CE 22-0050 for the property at 530 Lillian Drive. Is the city ready to proceed?
We are.
Go ahead, Mr. Trask.
Someone walking to the podium here.
It's me. Somebody earlier?
No, just wait. The city's got the burden of proof. So the city goes first and just sit tight, but I will give you the full opportunity to present to me anything you want to present to me.
Thank you.
Thank you. The city would call Deputy Snyder. Deputy, if you could state your occupation and your responsibilities here for code enforcement for the city of Madeira Beach.
Corey Snyder, Pinellas County Sheriff's Office. I'm contracted to work the city of Madeira Beach for law enforcement and code enforcement purposes. I've been in the city since 2016, providing the listed activities, code enforcement, and law enforcement.
Okay, we're here on the case for the property located at 530 Lillian Drive here in Madeira Beach. Are you familiar with that property?
Yes, I am.
Okay. And is this a proactive code enforcement case, or was it reactive?
It's reactive. In August of 2022, we received a written complaint from a neighboring property regarding short-term rental activity.
Okay, and who is the complainant?
The complainant was one Jeff Hughes at 528 Lillian Drive.
So it's immediately next door to the property at 530?
That's correct.
Okay, and what was the complaint that was made?
The complaint was short-term rental activity found on, it looks like Experian.com. It says I can provide a link if needed with the date of the complaint of 8/8/2022, the name and phone number of the complainant, and his email address.
Okay.
And he also provided the name of the address, the rental address, 530 Lillian Drive, and the name of the owner of the property as well.
Okay. Who is the owner of the property?
The tax role, and the Pinellas County Property Appraisers lists Gabriel D. Candido as the owner of the property, one of the owners of the property.
Okay, and I'm going to be talking about the agenda package that we have today, and specifically by page number. So I want you to take a look at pages 28, 29, and 30, and does that reflect the printout from the property appraiser's website? 28, 29, and 30.
28 is the Pinellas County Property Appraisers printout, which shows Gabriel D. Candido, and it looks like Trust, and Patricia D. Candido as the property owners of 530 Lillian Drive, Madeira Beach.
And that same information is on the tax collector's printout on page 31?
That is correct.
Okay. When the original complaint came in, who was the deputy that was involved in that complaint activity?
Deputy Jared Moraine.
Okay. And do you have any of his police reports or printouts reflecting the activity that he was involved in?
Yes, in August 18th of 2022, Deputy Moraine issued a notice of violation to Patricia D. Candido at the same address. The residential address for the D. Candidos is 12521 Frank Drive in Seminole, Florida. He issued a notice of violation in August, and having compliance date, August 18th, and having a compliance date of August 25th, 2022.
And what was the factual basis to determine that there was a violation of the code at that time?
We were provided with listings for the property, which showed the interior layout and the ability to book the property for $191 per night, with no minimums shown for that area.
All right, now you're looking at a printout. Could you take a look at pages 35 through 42 of the packet and tell me whether or not that this is the information or some of the information that was provided relative to the short-term rental?
That is correct. It describes a waterfront property, 3-2 bathhouse, open floor plan, Madeira Beach, Florida, with some interior photos. The listing was hosted by a Melissa, who I did not identify.
And on page 40, what is reflected on page 40?
40 just gives some of the amenities: canal view, kitchen, Wi-Fi, parking. This one here actually says 7 nights in Madeira Beach, October 12th through October 19th. And let's see here. Page 42 goes to discount $191 per night, originally $225. And there's it doesn't have the reviews, but there's a rating from reviewers that says it's got 4.67 stars out of 5 stars, and it says there were 3 reviewers that were making comments on the property.
Okay, so when Deputy Moran was issuing the citation, what was the actual code violation that was cited?
The section 110.176 is and pertains to R1 zoning, which requires a minimum rental of 6 months or less. Or, I'm sorry, 6 months or more.
Okay, were there any other cited code sections?
At the time, the registration for having a rental property was not obtained.
Okay. And so was there a citation issued then for that violation at that time?
No citation, just the notice that they had to cease activity renting the property
Okay.
in that fashion.
And is that the document that is marked on pages 43 and 44, the notice of violation?
That is correct.
Okay, and in that one, on August 18, 2022 notice on page 43, it references 2 code sections, 110-176 and 34-503, correct?
Correct.
Okay. Did the property come into compliance after that notice of violation was issued?
I believe it did, yes.
Okay.
As far as the rental registration, yes.
Did it go into violation again, subject to the August letter?
Yes, it did.
Okay, and when did the next time did it occur?
On September 9th, 2022, myself and Deputy Krager identified a renter in the property. We were given Deputy Krager went to the property, made contact with a renter who advised he rented it for a day, and subsequently he was issued, the property owner, Mr. Gabriel D. Candido, was issued a non-criminal ordinance violation citation for violations of Section 110, 176, and given a fine.
All right, and is that the citation that's shown on page 45 of the packet?
That is correct. That is correct.
And was this citation contested, or was the fine paid?
The fine was paid.
Okay. And was there a disposition printout at the clerk of the court's website that reflected a guilty plea by way of having the fine paid?
Yes, on October 22nd, 2022, there was a plea, short-term rental violation, less than 6 months. Guilty plea, fine was paid. Short-term rental activity less than 6 months, no trial, adjudicated guilty.
And is that reflected on pages 50 and 51 of the packet?
That is correct.
All right. Was there a report issued by your office for that particular violation?
I completed a Pinellas County offense report indicating that the citation was issued to the property owner, Mr. Gabriel D. Candido, outlining the activity for the day and the issuance of the citation.
And is that reflected on pages 47 through 49 of the packet?
That is correct.
Okay. Did the property fall into non-compliance again?
In March of 2023, I believe we've received information from the front desk that the listing was still being observed on the various websites. Myself and Deputy Krager proceeded to 530 Lillian and made contact with a couple that reported they were from Canada, and they rented the property for the month of March.
Okay, and what was the date that you went out to the property?
The date was March 9th, 2023.
And did you have your body camera on at that time?
Yes, I did.
And do you have a copy of that, or can you play that today for the special magistrate?
I do have that video.
Okay, if you would go ahead and do that. Tom, can you pull up the videos, the screens? There we go. Okay, thank you. And is there any type of time delay in the beginning of the tape?
There's a 30-second delay of no audio,
Okay.
and then you'll hear the camera click on, and then there's audio. There's complete audio of the contact at the front door.
Okay, that's what I'm looking for.
There's nothing missing from the point I exit my car.
And the address that you're approaching?
530 Lillian Drive, Madeira Beach.
This is the right one? This is gonna be the right one. Yeah. You remember the,
We can't tell, are you in uniform?
I am in uniform. Deputy Krager is wearing the same uniform that I was wearing on the day of the issuance of the contact and the citation.
Thank you.
is that the owner? Yeah. It's like D Candido. Yeah, that looks like right where I look. Is that who it is? That looks like him. Yeah. Morning, sir.
Hey, guys.
How are you?
Good.
Are you the property owner?
No, we're renting.
You're renting. Oh,
Yeah,
okay.
yeah.
My name's.
Jeez.
Sorry about that. Sorry to bother you so early. My name's Deputy Science with Debbie Krieger. We're just doing a real quick compliance check for the rental activity. Mind if I ask you just a couple questions?
Sure.
Rental properties have different zoning restrictions and rules that they're supposed to abide by. And we're just trying to follow up on a, oh, here we go. Here we go. I know, killer. There you go. No, that's fine. I know. You're a good dog. You're doing your job. Just a couple quick questions about the rental. How long did you guys rent for? Here.
Here till the end of March.
Oh, so what was the period that the rental, you guys started to when you're leaving?
Oh, sorry, we're here March 1st, we're leaving the 31st.
Oh, okay, a month.
Yeah.
March, okay, very good. March 1st through the 31st. You know what the total bill was for that length of time?
Okay, so we're looking at US funds, so just a second. It was about 5,500.
5,500 for the month?
Yeah.
Okay, very good. And then, did you see the ad on Airbnb,
Yes.
VRBO? Which one?
I think it was VRBO.
VRBO,
Like
okay.
it was like last August, so it's
Okay.
hard to read.
Okay. You guys don't have a car? You're Ubering around?
it's
Or-
in the-
Oh, it's in the garage?
In the garage.
It's
Oh,
so
that's smart. Very good. People don't normally, okay, all right, very good.
That's what I do with my.
Yeah, oh no, that's, usually there's stuff stored in the garage and, right, yeah,
Say more?
so.
Come here.
And then-
Police or?
Yeah, we're sheriff's office, we're for the sheriff.
We do rental inspections.
Yeah, we do all kinds of stuff. Make your
All right, thank you. That was what I needed to hear out of that tape. So to confirm then, they were there from March 1st to March 31st. They paid for a month at $5,500, and they saw the ad on VRBO. So, did I get that correct?
Yes.
Okay. And you issued a notice of violation after that initial contact with these people from Canada?
I did on the same day, I issued a notice of violation to cease rental activity at the property, sending it certified in regular mail.
Okay. And that is reflected on pages 52 and 53?
That is correct.
Did you also prepare a Pinellas County Sheriff's Office incident report?
I did.
And is that reflected on page 54 through 56?
Yes, it is.
And was that done on that, for that March activity that we just talked about?
Yes, it was.
Okay. And then did you issue a statement of violation and request for hearing?
Yes.
Go ahead.
We had a delay in hearing. April's magistrate hearing was canceled, so we set it for this May hearing for today.
Okay. So the statement of violation and request for hearing is on pages 57 and 58 of the packet, correct?
Yes.
And then the affidavit of service is on page 59, and you filled that out, correct?
Yeah, I did.
Okay. On page 60, if you could tell us what that is?
Page 60 is a copy of the written complaint from Mr. Hughes at 528 Lillian Drive, Madeira Beach, phone number, email address, name of the neighbor, the violating address, a brief description of short-term rental activity. I can provide links if needed, name and date.
That's fine. So, and then for the notice of hearing that you issued for today's hearing on pages 61 and 62, that's the notice of hearing, correct?
Yes.
And then what does page 63 reflect, or 63 and 64?
63 and 64 are photographs of the residents at 530 Lillian with the posting packet.
Okay. And then the last photograph?
Copy of the certified mail that went.
Okay. Did the city receive back the green card for the certified mail?
Yes.
Okay, and you have that with you today?
I have it here.
Okay, so we'll tender that into evidence as well in just a few minutes. So the purpose of today's hearing is to find the property in repeat violation of this code section 110-176, correct?
Yes.
Okay. And under Florida law, the fine would begin to run on the date of the inspection, correct?
Yes,
And it would run through at least the last day that you are aware of the tenant being in there, that would be March 31st, correct?
that's correct.
All right. And the maximum fine that could be levied by the special magistrate is $500 per day. What is the city looking for with regard to the daily fine?
I think the city is fine with $250 per day.
Okay. I don't think I have any other, is there anything else that you wanted to add that maybe I didn't cover that you thought was important that we should cover?
I don't believe so. There is someone in there now, but the length of their stay is unknown. I've not seen any lease agreements or statements, but we do have a new person occupying the residence now.
But he hasn't been cited for another violation at this
No.
point, correct? Okay. All right, at this point, I would tender into evidence the agenda packet pages 28 through 64 and the green card that would reflect that the notice of hearing has been received into evidence.
All right, Mr. Trask, I'll go ahead and accept into evidence as Exhibit Number 1, agenda packet pages 28 through 64, and then Exhibit Number 2 will be the green card showing proof of receipt, and it does look like it was received by someone whose last name was DeCandido.
Thank you, that's all I have for
All right.
Deputy Snyder.
Sir, are you going to speak on behalf of the owner?
I am Dominic Astarita. It's going to be Astarita.
Hold on just a second. First name was Dominic,
Dominic anywhere but Gue, Dominic.
and last name?
Astarita. That's Astarita.
Astarita.
ITA.
Okay. Sir, understand you're speaking on behalf of the property owner, is that correct?
Yeah, that's my uncle.
All right, great. I'm going to give you an opportunity in just a couple minutes to tell me anything you want to tell me.
Great.
This is specifically your opportunity during the hearing where you can cross-examine Deputy Snyder. Ask him any questions about the testimony that he just provided.
Yes.
Again, I'm going to give you a full opportunity to tell me anything you want, but do you have any questions of
I
Deputy
do.
Snyder?
I do. I have
All
a
right,
few
go ahead,
questions.
sir.
So in regards to the original, I believe, citation, Mr. Moran, is that correct? I actually met him down here because we had a situation where we felt like we were actually grandfathered in, because we do have our license, just so you know. I don't know why it's not being pulled up.
Questions. Do you have a question for Deputy Snyder?
Yes, so I guess my question would be, I don't believe we received any citation for this situation that you're talking about in March that I know of, or I would have addressed it way before then. So you said you sent the letter, but it looks like that was just received May 10th. So what happened to the original letter that went out from the original citation that should have happened back on March 9th? I have nothing, zero. Not a card on the door?
I can provide case notes that Deputy Moraine put into the system with phone calls and case notes that I was not part of, but from his complaint process to notice of violation to phone calls, case notes, and the issuance of Deputy Moraine's notice of violation, if you would like me to read through them.
I have one more question. So our original complaint from Mr. Moran was the original one on September 9th for the one day. That was also a situation where I spoke to Mr. Moran personally here and brought down documentation regarding our non-license, because a lot of what you're saying on here.
Questions, sir, questions.
So do we have anything from March 9th? Because we were immediately served on the September 8th situation, or whatever that was. So I was immediately notified that we had a problem, and we rectified that problem. Going into this one, I just never received anything in terms of information, which I thought as a property owner, or, somebody who's going to be fined / wind up here, that I would receive something physically, or even a verbal phone call. Because I have talked to Mr. Moran multiple times, so I do understand, exactly what's going on. It's not like we're trying to bypass any realities here, but my question is did you provide us with a documentation on that day of a violation? Because I don't see one.
So in September, I cited the
That's
property
correct.
owner
Absolutely. And
for
we
the
received
activity of the
same day.
short-term rental, right?
Correct.
So in March of 2023,
That's what we're talking about.
I issued a written notice of violation.
Yep.
And mailed it to the Frank address in Seminole.
That's correct. Now, is that the one we received May 10th is my point? So we're getting a month gap,
Whatever
2
date was
months gap?
received, yeah, but it was, that notice was issued certified that the rental, short-term rental activity needed to cease immediately. That was mailed, both regular and certified mail, in March of 2023.
Okay, and we have that certification that you said you received in March, because the one you have is May 10th. So that's why I'm confused here. Did we receive something on March 9th or not?
May 10th would be the notice of this hearing.
Correct. That's correct.
March would have been the issuance would have been the violation, we identified a subsequent repeat
I did
violation.
not receive that part of the violation, is what I'm trying to get at. So whatever documents.
The one that's on the screen, you didn't receive that.
I did not.
Do you live at 12521 Frank Drive?
My uncle does, and I collect all the mail. We go through it daily. So again, I'm very up to date on what's going on here. So as we proceed, I think you'll see a little bit further where my point's going to be. But I'm just simply saying I didn't receive notification, and if it was sent, I didn't know. So that way, it would have been addressed far before this hearing in terms of what we're dealing with.
Sir, are you the property owner?
I am the son or the nephew of the property owner, and I handle everything in terms of rentals, everything. So we can put oath up, there's no problem, everybody knows who I am. The complainant is actually here. We did not have a relationship when this was.
Any other questions for
No
Deputy Snyder?
questions after that.
Thank you.
Just definitely handled that. Thank you.
Mr. Trask, is there anyone else that you'd like to call on behalf of the city?
No.
All right. Sir, I told you wouldn't have to go far.
Yes,
All right,
thank you.
This is your opportunity during the hearing to first tell me anything you want to tell me. Then if there's another witness or someone else you want to call, we'll do it that way. So
That's perfect.
first, give me your, whatever arguments, whatever evidence, anything you want me to
Okay,
consider.
I'm not trying to, I don't think it's an argument. I think it's more of being in limbo. So initially, we've owned this property since early 1996, 95. We've always had it as a rental property, and we always have had a license. Now, when I came in, I was able to pull up online, you're a little pursuant of 2006, you had to have it prior to, and if that was the fact of the matter, from what my understanding was, in reading it blatantly, that you should be grandfathered in. So that was our original mindset in terms of what our rental factors were and how we determined, our daily, monthly, 6 months. We were never intentfully on trying to do or break any, let's say, local laws. That wasn't our intention. With that being said, when I did get my initial citation from Mr. Was it Morales, or he's a very nice gentleman, met him actually here. I did hand him our current license at that time, and I showed him the documentation back to 2006, and his recommendation was, hey, Dominic, bring it into the courthouse with you when you go for this $85 citation, and this should be taken care of. I dropped off some documents to the front desk downstairs, and there was just never any follow-up on either side of the parties. I should have got an email. I did call a few times, and it was just one of those things where the ball got dropped. But at the same time, I knew that we had the license. So in my mind, I felt like we did have a right to rent. And the worst part about it is, so now we're coming up with a $250 daily citation. This was our first actual citation. The gentleman who was there on that date, and Mr. Morales, I wish he was here to speak on his behalf, he was a good friend of mine. His name is Philip Black. He did not rent my property. His daughter was going into the Marines the following weekend, and he asked me if I had some place he could stay, and I let him stay for free. I did not charge him, and he is more than willing to put an affidavit together stating that. Had I known we were pleading guilty to something like that, I would have definitely done something different rather than just pay an $85 fine, because the only reason he did not come on my behalf was because he lived so far away. And I just didn't think it was going to be drawn out to this far, because I figured we would get grandfathered in once I brought the documentation down. So that is part of, where the limbo comes in. We don't know the full, a lot of what's in here says we don't have a license, but we do have a license. So I'm not saying you guys are incorrect on some of the things with the follow-up and the coming out and having residencies there, but I also believe that there's a crack that's a slippery slope that we fell through, and I just need to know where we stand, because we don't need to do short-term rentals there. If we have the opportunity, of course, it's great to have flexibility in terms of rents, and that's great. But at the same time, we respect our neighbors. We're great friends with all of them. So we don't just come in and try to, shove people in a house next door when we know, there's a potential problem with anybody. So first and foremost, I'm just glad that we have the opportunity to all hear each other, because I think this is the best way to get the resolution that you're looking for, and give us a definitive answer, like where do we stand? Because not knowing where we stand makes it very difficult. And now looking at the fact that I actually took a fine that I should not have, and that's my fault. I'm not going to blame anybody for me not dragging my friend down here from Wesley Chapel, but that was my fault, and I should have, because that would have never stuck. So with that being said, I don't believe that was a real violation. It was not a violation. Unfortunately, I did not handle it on my side the way I should have, so I violated myself. There was no renter there that day. With that being said, moving forward, I did provide documentation to the city, trying to find out, okay, who's grandfathered in and who's not? I have had the license. I mean, on this document right here, it says that I don't have the license. I have it right here in my file, going back, 3 years. So for a license I don't have, then how do I have it? Furthermore, we did have a license pre-2006. So how that doesn't reflect, that's where I have to stand here and say, okay, here's my argument. Moving forward, we have decided, and actually Jeff is the gentleman who is right here. He is the one who actually sent that original complaint in. That was very early on, before we even came into the house and were redoing anything. The house was dilapidated, a lot of very serious problems. So we were trying to figure out where we were going to sell it, buy it, rent it. We were kind of in the limbo there. Seawall fell in, roof fell in. We had some major sinking issues. So we put it up for sale thinking, okay, we might sell it, or we'll go ahead and make this into what it's always been, which is a rental. And then here we are. So if I had known about the March 9th incident, again, I would have been here before, and I would have already gotten my documentation together to say, hey, guys, look, here is my license. So, I mean, just like right off the top, just pulling these right out, these are just my last 3 years of licenses. So to say that we didn't have them, I mean, it's just a
No,
false statement.
I understand. You've made that point clear
Yeah,
to me.
well, I mean, I wanna
And the
make sure
city,
it's-
and I want Mr. Trask to correct me if I'm wrong. Today, the city is not asking me to find you in violation of the 34-503, which
Yep.
is the licensure. I think the city concedes that you have
That's correct.
the license. So thank you for telling me that.
Okay.
I'm accepting your representation that
Yep.
you are not in violation
Yep.
of 34-503, and the city's not asking me to even hold you in violation
Okay.
of 34-503. I'm going to let Mr. Trask ask you some questions.
Absolutely.
If he has any, but I just want to make sure I understand your argument is that Mr. Black was not a renter, he was there just.
And I can
you gave
provide
him-
documentation.
I got it, I understand that. And then I think your other argument is that you believe this property was grandfathered in to something that would allow you to rent it for less than 6 months.
And
Am
it
I
should be.
understanding your arguments?
And it should be. And I
All right.
brought those documents down.
Mr. Trask, go ahead.
Just a few questions.
Yes, sir.
You're not the owner of the property. I think we established that, correct?
My uncle there. is
Okay.
Right here.
All right. And what is your connection to the property? Are you getting paid a fee for the rental aspect of the
No,
property?
my uncle and I own multiple properties. We have multiple corporations, so we don't take fees per se. Just depends on what property is and how we receive compensation. So each one of them is different. So for me to give you a specific how we split our denominations up is just not something I can do.
Okay, I just wanted to make sure, I didn't know that you were in partnership with him. So you don't deny that the citation that was originally issued last year was paid, correct?
That was something that I paid myself, and the reason why I did not dispute it.
You've answered my question, I just want
Yes,
to make
sir.
sure.
I do not deny that. I paid that, correct.
Pat, can you, Tom, is there something you can do to correct that? Sure, everybody.
With all due respect, I'm going to grab a sip of water while we're,
Yeah, go ahead.
Yeah, go ahead. We'll just let him work on that so we don't have that distraction. Hold on.
Okay. Okay, so I just asked you the question relative to whether or not that the citation that was issued was paid, and you
Yes, sir.
answered correct.
that's sir, I
okay?
paid it.
And with regard to Deputy Snyder being on the property, you saw the video cam. You're
Yes.
not disputing the fact that you rented this property from March 1st to March 31st, correct?
Not at all.
Okay. And you don't dispute the fact that you were paid, or the renter paid $5,500, whether you received all of that or some of that?
Yeah, there was definitely monetary monies received. So again, without having to pull it up and show you, I would not know that.
Okay.
But
In
I
addition, you've answered my question. In addition to that, there's no question that you're renting the property on VRBO, correct?
Not currently, absolutely not. I've taken everything down. The second I realized that we were in violation, which again, this is why I'm discussing the March 9th situation, we have automatically taken everything down because we're not trying to pull a fast one on you guys. We understand there's been an issue with VRBO, Airbnb throughout this county, through Reddington Beach, so we understand that. But more importantly, I think our argument is that we think
Well,
that we
you've
are-
answered my question. This isn't the time for arguments.
Okay.
Oh, so you did have it listed on VRBO, correct?
It's not on VRBO, no. There's no
My
openings.
question to you, was it advertised on VRBO?
It was not available, no. It's on the website with X's, meaning you cannot go in our property and book it. Zero at all. The answer is no. So I'm answering no to that question.
Prior to March of 2023, it was on VRBO, correct?
Airbnb, it was crossed out completely prior to March.
All right, tell
And
us
you can
then,
pull it up, it's there. It
when
was
did
gone.
you stop advertising it on VRBO?
The first of the year, when we decided to rehab the property.
First of this year, 2023?
Roughly, I mean, it could be
Okay.
December, I'm not gonna say exact dates without going into my system, and I can give you that date, but ultimately, we decided at that point that we were gonna do the full rehab, and we were gonna make the commitment to bring the property back up to where we considered rentable for a annual lease, of course.
That being said, it was rented through VRBO for this couple in March of this year.
That is correct.
Okay.
And that was a prior rental from months before, and I did actually try to cancel that. And the reason I could not, it was going to cost them a substantial amount. It was going to cost me a substantial amount, and my properties that are in compliance would have gotten a negative impact for it. So I simply said, hey, and I told them, if somebody comes, please let them know. Do not hide from them. Do not tell the truth. Because again, my whole objective of being here is to determine if I'm actually grandfathered in. Because if I am, then this is a great conversation, but that's what it's going to be. If I'm not, then we can discuss it. But I feel like, I've made the necessary things on my side to show and provide documentation in regards to prior 2006, because that's a big date.
All right, I'm going to ask you a couple more questions.
Yep.
After March 31st, did you rent the property?
No, sir.
Okay, is there a renter in there now?
Yes, sir.
Okay, and when did you rent the property to this person?
That would be May 8th.
Okay.
Their house caught on fire, 4 houses down our road.
Okay, and do you have a written lease?
Absolutely, for 6 months and extended if need be.
Okay, that's what I need to know, thank you.
Absolutely.
Have you seen the photographs that were tendered into evidence?
I believe the ones that we all visually just looked at?
That were shown on the screen, did you see those?
I did, of
Okay,
course.
that's your property, correct?
Yes.
Okay, all right. All right,
She showed me something I didn't see. You're talking about 530 Lillian, right? Yes, that is our property.
okay, that's what I was, thank
I'm not
you.
going to deny. I'm not here to, that's our property. That's my
Okay.
furniture. I bought it. Facebook Marketplace, cheap.
All right, now, you had mentioned that you'd brought some paperwork into the city.
Yes, sir.
What paperwork did you bring?
So I was going online to try to establish what is considered grandfathered in. Very simple, because February 28th of 2006 is an imperative date to a lot of people who actually have rentals. And so I'm one of those people. We have rented this consistently from 1995 or since we bought it.
I just asked you, what did you bring into the city?
I bought in the document that she didn't even know existed, because she told me that at the time, and it basically was a document from the court that stipulated how and who and why you'd be grandfathered in, and that is the form I brought her. And I renewed on the same day my license.
Okay, do you have a copy of what you, first of all, who did you give that to at the city?
There was an older lady at the front desk, and I gave it to I want to say maybe Lisa, am I correct on that? Is that
I don't, I'm trying to figure that out.
I can't answer that. She came in from the back, and she handled specifically what I was dealing with, because the woman up front called her to come up, because she was the one that dealt with that situation. So you guys can probably really figure that out pretty simple if you go downstairs and just ask who handles that part of that. Because she
Okay.
came out, she said I would get an email, she would look into the fact of how long we've had our license, et cetera, et cetera. And at that point, I mean, the ball completely just got dropped. We did not have sheriffs coming out anymore. So I honestly thought it was resolved. I really did.
Do you have a copy of the document that you dropped off?
No, but I'll print it off right when I walk outside and bring it to you. Actually, I tried to get it today. It's a public document. It is from the municipality of Madeira Beach. And so way back when, I'm trying to remember his name. His name was Max something. He was the city manager way back in the 90s. And I remember dealing with some of that stuff. But I do have the document. I can very easily pull it up. It's a public document, and it's from the city of Madeira Beach, not the city of Dominic. So it's got your whole little deal on it.
And what does the document say?
It says that if you had a license prior to 2006, you were grandfathered in. And if you give me a half hour after I leave here, I will go print you two.
Okay, well, we don't have a half hour. This is the
You
time to
understand,
present your
I'm simply saying
case.
it's there. It's definitely, you have to dig in to get it. It's a PDF from Madeira Beach, though. It's not a PDF from Largo or anywhere else. It's this municipality specifically, which is why I brought that in with my license to show both of them to try to find out, hey, look, where do we stand? I think
Okay.
that's simple.
Did you bring in any documentation that reflect that you were short-term renting the property from sometime prior to 2006 all the way up through 2023?
And specifically, what are you asking me for?
Anything that you would?
No, I did not.
Okay.
Well, I didn't feel the need to at that point. Remember, I'm not trying to defend myself. I was simply trying to find out why, and that's why I spoke to the detective as well. Why were they coming out if we're grandfathered in? So I brought the documentation hoping that once the follow-up happened, we would have the real answer, and we just didn't get one.
All right, I've got a couple more questions for you. I know I've said that a
And I
couple
did
of times,
provide
but
that to the deputy, and he did tell me to bring that with me at the time if I was going to fight that ticket, and I just didn't fight the ticket, so I didn't bring it. But you can ask him. I met him right there in the parking lot.
all right, I've got some questions for you. How many times was it rented as a short-term rental in 2023?
In 2023, and I have to really think for a second. No, this year, we've had it rented twice, this one and the last one.
Okay, in 2022, I'm going to go back a couple of years, okay? So in 2022, how many times did you have a short-term rental there?
2022, we had somebody come in, so it was only a half a year. We remodeled in May through June, July. We had a person come in who had a flood in their house down the road, so that was July. They were there for 3 months, so I would say maybe 2 or 3 at the most. Again, I'd have to pull my documents, and I have no problem pulling everything up to be able to solidify.
Okay, in 2021,
0. We had long-term,
okay, in 2020,
long-term.
how far back was it long-term rental?
So we had a little cohesive list. I would say it just depended on how good our tenants were. If we had a good tenant and we appreciated them, they stayed as long as we could keep them. And if we had a bad tenant, it might have been a year lease that wound up for 3 months. It might have been a 6-month lease that wound up for 2 years. So it really came down to who our occupant was and how well they treated our property and paid.
It's fair to say, though, that from 2019 through 2021, you did not have any short-term rentals.
I would say that's fair to say, yes.
Okay. I don't have any other questions for you, sir.
Okay.
Thank you.
You're very welcome.
All right, sir, is there anything else you want to tell me about this particular code violation?
I mean, I think you guys heard everything I had to say. I mean, for me to try to keep arguing, I can just simply say I'd never turn my back on this situation. I never did not try to ramify it. And like I said, I mean, I brought the documentation down. I can't tell you why you guys don't have it. I'm sure did you find that piece of paper I was talking about by any chance? I saw you looking. Grace, were you able to pull that up by any chance? Okay, because I think that will definitely help out in regards to just simply seeing where my argument is.
Well, let's do this. Do you plan on calling any other witnesses or anything else
Yes,
like this?
Jeff is the complaint.
All right.
Complainter, or-
Why don't we do this? Let's hear from Jeff.
Absolutely.
And then I'm interested to see whatever document you have, and I think Mr. Trask could be interested to see
I will
what
get that
document you
document
have.
for you.
So,
I'm local. I'll
well,
get
what
it.
we may be able to do is, we've got one other matter after you. We can take a short recess and give you time
You got it.
to go find it. But let's hear from Jeff. I don't know your last name, so if you come forward and give me your last name.
Hi there, I'm Jeff Hughes.
All right, Mr. Hughes, what would you like to tell me?
I'd just like to let you know that at the time of the complaint, Dominic and I did not have a relationship, and since then, I would say that we do. And as I told him on the phone this morning, that we probably wouldn't be in this situation because I would have had a conversation with him rather than law enforcement. I will say that the property has been a long-term rental. I've lived next door to that property since 1998, and it has been a long-term rental up until the dates that Dominic had shared with you. I do have a vested interest in seeing that it not be a short-term rental, and I've shared that with Dominic. I have an investment right next door, and I do think that short-term rentals take away from your property value. But he is making those changes, and I hope that the fines that I've heard are not as extreme as what they could be.
All right, thank you, Mr. Hughes. Mr. Trask, you have any questions? I'm treating this as a witness of the respondent here, not just a member of the public, so feel free to
Gotcha.
cross-examine.
No questions.
All right.
Thank you.
Thank you. All right, Mr. Astorita, is there any other witness you want to call on your behalf this morning?
No, I wish Mr. Moran was here, because I would definitely call him, because he was, he's a great guy, young guy. And I did absolutely speak to him directly the same day I was cited the first time. So I think that would have a little merit, but unfortunately, he's not here. He's been moved to another section, I believe, Reddington or wherever it is. So I did try to follow up on that as well, because I do have some sheriffs that I work with, and I just figured if I could go ahead and get his, words, letting him know that I did do my diligence, not just try to hide in a corner and, not address any of the problems, because every problem that's come up, I've addressed, for sure.
All right, thank you, sir. Are there any members of the public that are here to speak on CE 22-0050? Any members of the public? All right, seeing none, let's do this, Mr. Astorita. I'm going to go ahead and we're going to be in recess. I'm going to give you an opportunity. I don't know if I can give you 30 minutes because I don't know how long this one will take.
If you can
But I'm going to
get
give
to
you
a
15
computer-
minutes to try to find whatever written documentation you believe the city provided to you that said your property was grandfathered in to whatever, where the
I'll
six-month
provide you
short-term
with a
rental wouldn't
document
apply.
that was drawn up by the city municipality. Now, it's not for Dominic, it's for the grandfathered in properties that qualify under certain statutes. That's the document that I brought, and that's a document that
All
I
right.
will absolutely have.
We're gonna be in recess for 15 minutes for this one.
Yep.
I'm gonna move on to the next one.
Yep.
When you come back in, we'll jump back to this case,
Sounds
okay?
good. Is there a local public computer I can use with a printer so I don't have to run home to do this? If you
I
get 15
don't
minutes, it's
know.
15 minutes.
No, they won't allow that because it's the security reasons for the system.
Okay.
Okay.
I will do my best to be back in 15
Okay.
minutes. I can't tell you that I can't speed, sheriffs are out there, but I will absolutely get something back as soon as
All right.
possible.
All right.
Thank you for your
Okay.
time, guys.
All right, we're gonna move on to case number 2022.3387 for the property located at 13227 Second Street East. Is the city ready to proceed in regard to that agenda item?
Yes, we are. Just first of all, I want to give you some background on this one. You'll probably remember it anyhow, but this is the property on Second Street East. The code enforcement case was Bernard Scott. This was originally heard by you in August of 2022. At the hearing in August of 2022, you issued an order. I've got a copy of it here if you need it. But the order provided that the property owner was in violation. And under paragraph 2 of your order, it says the respondent shall correct the above stated violation on or before September 30th, 2022 by taking the remedial action as set forth in the notice of code violation and stated on the record at the hearing, which is to obtain a building permit or remove all unpermitted work. Because of some issues related to health and some other matters, it came back before you for a request for an extension of time, and you entered another order extending the compliance date until December 30th. So we're now from August 1st to December 30th to bring the property into compliance. Today, we have for you an affidavit of compliance reflecting that the property is now in compliance. That is on the packet on page 65, reflecting the property is in compliance. That affidavit of compliance is dated April the 7th. I would have you note, though, that it came into compliance on April 6th, and that is reflected on page 78, which is the inspection field sheet. So it was actually a day earlier that it came into compliance. Also in the packet is an affidavit of service, a notice of hearing for today, a photograph of the posting, and some inspection field sheets, and we can prove those up here in a second if need be. But on page 72, there's an inspection field sheet showing that an after-the-fact permit for a demo was passed. That's on page 72. There's a photograph of the property on 73, 4, and 5. He was also required to obtain a permit for siding and pavers. The property owner did do that. That was completed on January 31st of this year. That's reflected on page 76. And on page 77, it reflects that a permit was issued for the roof and soffit work on February 20th, 2023. The difference between February 20th, 23 and April the 6th was with regard to a garage door that needed to be installed. So with that as some background, I'm going to call Mr. Pinkard to testify. I did swear you in earlier, didn't I? You swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? Okay. I need you to take a look at page 65 of the packet. That's your affidavit of compliance, correct?
Yes.
Okay. And it's dated April the 7th,
Correct.
but the property actually came into compliance on April the 6th, correct?
Correct.
Okay. And you're doing that pursuant to direction that you received from the building official?
Correct.
Okay. You did not issue the affidavit of service or the notice of hearing. That was Grace, correct?
Correct.
All right. So that's the only question I've got for Mr. Pinkard. But I want to prove up also the rest of the documents through Grace. So I don't know if we want to cross-examine.
Yeah, Mr. Lavender, is that you? Obviously, Mr. Pinkard's testimony was very brief. If I understand, because I received something from an attorney on your behalf, I just want to make sure that this attorney represents you. Allison Duchette?
Yes.
All right. And if I understand the request that you're making, it's essentially, you're telling me that you are now in full compliance. However, you're asking me to reduce the fine that would have accrued on the property. Is that essentially what you're asking me today?
Yes.
Okay. Before we get too far afield on any of that, you heard Mr. Pinkard asked some questions. Do you want to cross-examine him on anything that he just testified to?
Nothing what he's testified to. I mean, we've
Okay.
been in,
I'm going to give you a full chance just in a minute, but this was your opportunity for cross-examination. Just have a seat. You don't have to go far. Mr. Trask, who would you like to call next?
Grace Mills. Grace, you did take the oath, correct?
No, not yet.
All right. You raise your right hand and be sworn under oath. Swear the testimony you're about to give is going to be the truth, the whole truth, and nothing but the truth? Okay. Your name and your occupation here at the city?
My name is Grace Mills. I'm co-compliance officer for the city of Media Beach.
Okay. Are you the person that issued the affidavit of service on page 66 and 67 of the packet?
Yes.
Okay, and did you also issue the notice of hearing for today's hearing?
Yes.
And that's reflected on pages 68 through 70?
Yes.
And can you just go through the last few documents that are in the packet and explain them for the special magistrate?
Would they be the
Starting at page
photos?
71, the photos?
Yes. So let me just get to it. I believe it's going to be 71 is a photo of when it was posted on the actual property.
What was posted on the actual property?
Let me get up to the document. Just one moment. That would have been a copy of the notice of hearing. It also is a copy of the affidavit of service. And I believe it might have been the affidavit of compliance as well in that packet.
Okay. And can you explain what's on page 72, 73, and so on?
'72 looks like our inspection field sheet from our building official that was passed. That looks like December 27th, 2022.
What was that for?
This was for an after-the-fact permit, selective demo and garage only.
Okay. Next, the photograph on page 73.
73 would appear to be the garage with plywood over the door for the garage door.
And pages 74 and 75.
74 and 75 look like the side and back of the garage with demo work, as that's what it appears to be.
All right, and the next three pages, starting with 76.
76 is going to be one of the inspection pages. June 18th of this year for siding pavers by garage only.
What date?
I'm sorry, May 18th.
Okay.
And then the following page, 77, is inspection field sheet for the same day for roof and soffit extensions, which they both passed by our building official.
And then the last page?
78 is the inspection field sheet for the same day for precision door, or excuse me, garage door, which was passed as well.
Okay, thank you. I don't have any other questions for you. We would tender into evidence packet items 65 through 78.
All right, we'll go ahead and accept into evidence as exhibit number 1, pages 65 through 77 or 78?
78?
78, okay. All right, Ms. Mills, I just want to make sure, I want to confirm, the property is now in full compliance, correct?
I believe so, yes.
Or of whatever I found a violation of, the properties, all those violations were corrected, or all corrective action was taken by the property owner as of April 6th, correct?
I believe so, yes.
Okay. Ms. Lavender, any questions of Ms. Mills? Okay, the applicant, or the property owner says no question of Ms. Mills. Ms. Trask, any other witnesses?
Yes, I would call the building official, Mr. DeSantis.
All right.
Frank, were you sworn in?
Yes, I was.
Okay. Just a few questions about the field inspection sheets and when the property actually came into compliance. Can you explain what was happening between February 20th, 2023 and April 6, 2023, why it took an extra month and a half for the property to come into compliance?
Well, according to the records, we did the demo final, which was the first permit that was pulled. And you go to the next permit that was pulled, that was for the siding pavers in the garage. And that was finalized out on January 31st. And the last permit was for the garage door. And from what I understand, there was a delay in getting the garage door. That's why it took so long to get to April 6th.
Was the garage door required for the property to be brought into compliance?
Yes.
Okay, and what was the reason that you believe the garage door was necessary to have the property brought into compliance?
It would identify the garage as a garage.
Okay. Without the garage door, it would not be considered a garage?
Nope.
Okay. All right, I have no other questions for Mr. DeSantis.
Mr. Lavender, any questions, any cross-examination of Mr. DeSantis?
Yes.
All right, come up to the microphone, sir.
Mr. DeSantis, so when we were in this room last together, so, and I believe Ms. Rowan, she was the, I guess, the building code compliance person at the time. I think she was sitting in that chair. I'm not sure her exact title. I asked the question, reading the code, whether or not the door that was there, whether it met the requirements. And per the code, she told me, yes, it did. After we met in this room and we had the conversation, we met with her in your office, in your conference room. I asked the question again. She confirmed that per the definition of the code, it met the requirement, and you responded back to me that it's at the building official's discretion, and I want you to put a garage door up. Despite my understanding per the code that having a door is not required on a garage. It's your interpretation of you want to have a garage door on there. So I spoke to a registered architect this morning who told me a garage door, if I wanted to leave it without a garage door on it, I could do that. So the original door met the definition of a door in a garage, and it's not required to have one. So why, at your discretion, why is it required? Why did I have to spend $5,000?
Well, the garage door was required, in my opinion, and as the opinion of the county, Niles County, that's defined as a garage. Not French doors, but an actual garage door for vehicles.
When we met with Ms. Rowan and we reviewed the definition, the former door met the requirement of a motor vehicle being able to be brought through it. It didn't say garage, there was a door to accept a motor vehicle.
I'm not,
Oh, it's on record from our last hearing.
I can't speak for Ms. Rowan, as far as how she defined it. She might have defined it in planning and zoning, but in building, it's a garage door.
So, all right, that's all I have for you.
Mr. Trask,
No
any
re-
additional questions?
No, sir, no redirect, no additional witnesses.
All right.
I do want to address the letter, though, if we're going to get into that.
Yeah, sure. Let's, why don't we do this? First, Mr. Lavender, tell me what it is you want me to consider. I'm going to let Mr. Trask do his cross, and then we'll get into whether you want to try to put this letter into evidence, and we'll deal with any objections Mr. Trask may have. So just tell me what you'd like to tell me.
So when we met the first time here, after we left that hearing, I met with Ms. Rowan and Mr. DeSantis to review the property. We had a meeting on what I could do to try to bring it into compliance, because it was my understanding at that time, which I subsequently provided evidence of, that building had been built out 38 years ago, and it was originally done so as a garage apartment. Now, through several FOIL requests, we found out that it had been permitted for about a period of 5 years. At a certain point, the city came back and said, you can no longer use it as an occupied space, and further instructions on what to do next will be forthcoming, which they never did. I had an affidavit from the original property owner. I provided photographs of Mr. DeSantis and Ms. Rowan of it being built out 30 years prior to, and that we have the FOIL request that no instructions were given to return it back to a garage structure. So I did my best to work with them to see if I could find some common ground to keep the space. We got to a point where it determined that they were not going to allow me to do that. So Mr. DeSantis walked me to the permit rack. He told me, if you file a demolition permit, that'll freeze the fines. So I got the demolition permit, I submitted that, then I found out a couple weeks later that that was not the case, that I had to complete the demolition work in order for that to happen. So I did that. I had that completed by the end of the year. I thought I was in compliance. Mr. DeSantis came, he inspected, I asked him, are we good now? He said, absolutely. I said, I'm getting an architect to take care of the other miscellaneous items, but it's going to take a little bit because it's more of a nuisance project. He said, I completely understand. Then I think I wrote Mr. Trask to confirm that. He said, no, that's not the case. He had spoken to Mr. Holden. My point being is I've gone above and beyond to try to comply, and even though I felt it was being unfairly imposed upon me, I listened to what I was told to do. It was a painful, long, and expensive process. This has cost me thousands of dollars that was unnecessary since this was built at 38 years ago. And I don't think that I should be fined because of that.
All right, sir. Mr. Trask, any questions?
No, I don't have any questions of Mr. Lavender.
All right. And I did read what your attorney sent in as well as all of the backup. And I understand, if I understand your request, Mr. Lavender, the property would currently have fines on it in the total amount of $9,600. Is that correct?
Yes.
And your request of me is to eliminate that fine in its entirety. Is that correct?
Yes.
All right. Okay. Mr. Trask, do you have any follow-up questions from?
No, I don't.
All right. Mr. Trask, do you have any opinion on what should be done with this letter that was sent to me on May 19th, 2023 by Ms. Duchette?
So I think that this matter needs to be set for a fine reduction hearing. This was not properly noticed for today. I received it over the weekend. I guess it was on Friday. I saw it for the first time this morning, and city manager is out of town on vacation. I have not had the opportunity to discuss it with him on taking what our position is on it. And so I'm asking that you do find the property in compliance, and then as for the fine reduction request that Mr. Lavender is talking about, notice that for hearing, and let's discuss it at the next regular meeting, because it has not been noticed for today.
All right, you understand what Mr. Trask is asking me to do, Mr. Lavender?
That's what I thought the purpose of this meeting was today.
Yeah, well, we need to get the public notice done correctly, because if I was to rule in your favor, and then somebody, the city could even appeal in theory because it wasn't noticed properly, or some member of the public could say it's not noticed properly. So I'm going to go ahead and find that your property is in compliance. I'm going to treat your request as a request for a fine reduction hearing. You heard what Mr. Trask said. He's going to talk to the city manager. You guys may be able to resolve this administratively, and it won't be able to come back before me. But as a placeholder, do we want to put it on the June agenda?
Yes, the next meeting.
Okay. Are you, Mr. Lavender, are you available for the June meeting, or?
To the best of my knowledge, but I'd have to go and check with any family obligations or work obligations.
All right, I tell you what, we're going to go ahead and I'll ask city staff to put us on the June meeting. If for whatever reason that June meeting doesn't work, we meet every month. And so we'll roll it to July if that's what you prefer. But for right now, we'll set it for June. We'll notice it publicly as a fine reduction hearing. And I would encourage you to follow up with Mr. Trask, or maybe your attorney can follow up with Mr. Trask to talk to the city manager to see if there's a way to administratively resolve your request. There might be, I don't know. Meaning you won't have to come back before me for another hearing. You and the city can agree to something. So again, that's going to be between you and the city.
Can I reach out to the city with Mr. Trask directly instead of having to pay my attorney to do that?
Doesn't bother me, but that's up to Mr. Trask, so.
I just need to send a quick email to your lawyer to ask her permission to do that, but the answer would be yes otherwise. Okay.
All right, so right now, if nothing changes, plan on coming back at our next special magistrate hearing, and we'll get you on the agenda as a fine reduction. But your property is in compliance right now, and I'm going to go ahead and make that finding. I'm going to send you an order saying your property is in compliance.
Okay.
All right? Thank you, sir. All right, that concludes that hearing on 2022.3387. Now, we had previously taken a recess for case number 22-0050, and I see the property owner is back. Were you able to find some documentation?
Here with a smile, yes, sir.
All right, why don't we do this? Let's just take a 2-minute break. Why don't you first present whatever you want to present to Mr. Trask, and let him evaluate what you have. He may have some evidentiary objections to it. I want him to have the document first. So we'll just take a 2-minute break.
Are we taking a break now, or am I getting the document?
No, we're just going to go off the record for 2 minutes, and you can walk up here and show Mr. Trask what you want to show him.
And just for the record, actually, when I brought this document down and I gave it to her,
Make sure you're on the microphone.
she did not know it existed.
Okay, so go ahead, Mr. Trask, take your time to inspect that document and ask the landowner anything you want to ask.
Is it okay if I stand? Thank you. Beautiful place you guys have here, by the way. It's nice.
Actually, Holden, if you can just bring it up on the screen, that will be fine. Okay. All right, I've had the opportunity to review it now.
All right. So, Mr. Trask, procedurally, I think where we were essentially we've gotten through the property owner respondent providing information. There were no public comments.
Mr. Hughes testified.
Right, and so do you want Mr. Hughes to testify about that document? You ask him questions? Do you want to go to an argument relating to that document? How do you want to proceed?
Well, Mr. Hughes is gone now, so
Okay.
this is Mr. Astorita.
I'm sorry.
Yeah, okay.
Yes.
I just want to get
Okay.
the right players.
It's been a long day.
Mr. Astorita, correct. And Mr. Hughes testified as a property owner that there were short-term rentals, but he's talked to you about that. So do you want Mr. Astorita to answer questions about that document, or, okay,
No, I have no objection for it being received into evidence. I'm going to pass it on down.
okay,
Okay.
all right. Thank you, sir. Give me 1 second to read this
Absolutely.
document, okay?
Took me a long time to find it.
All right, sir, I've read this document, and I'm going to go ahead and put it into the record as Exhibit Number 3. So what is it you'd like to tell me about this document,
So
sir?
I think the main thing was just the unknown with that document, and just when I came in to get the particulars, which would give me the proper, answers that I really needed to not have and avoid this situation here, I just didn't get. So again, I did follow up, and I did not get Section D there. I was never pointed out as she wrote it and read it. We did have a discussion via the phone, and the answer that I'd gotten was she was still looking into it. So to me, that's not a yes or a no. That is definitely putting me in a gray area. And furthermore, I think the most important thing here is moving on and moving forward. My neighbors are wonderful people. I'm great friends with them. We've already discussed whether we get our license or not. It really doesn't matter at this point. We are doing a major renovation there, and we are only going to have long-term renters in there from this point forward, as we already do. So I don't think we're going to have any more issues in terms of violations, whether you give me a grant or not. This is just trying to get you to understand why and where our mindset was as we were doing the rentals. And I did pull those off months ago. So if you were to go on Airbnb, and unfortunately, there's other websites out there that will actually drag some of your listings that have nothing to do with that particular website, and they exploit your property without permission. So I can't talk in terms of Expedia, but I never, ever was using their website at all. And I think Jeff coming in here and speaking on my behalf kind of speaks a lot about, who I am as a person and who we are as homeowners, and, what our real intention is, for the neighborhood itself, not just ourselves. We're not here to make a quick buck. We've owned that house for many, many years. I think if I had to pull more neighbors in, they would be more than happy to do that for me. And at the same time, I think that fine is absolutely probably a little bit steeper than I would expect or deem, I think, fair. I do believe I do have a case at some point. I don't believe that I want to fight it, though. I'm not here to fight City Hall. I'm not here to say you guys are wrong. I was looking for answers, and I think after today, we're going to have those, and hopefully I don't leave here with a big scar on my backside in the meantime. But I do want you to know our intentions are good, and you can come out at any point in the future. There was a couple of inspections, and here's where it gets a little bit more conflicting. We were told that we had inspections. Well, there was no inspections done. So how can I violate an inspection, that never happened? So again, these things are really, I think, moving forward, probably need to be a little bit more clearer, and it would probably help out a lot in terms of not having to deal with this situation. But, when somebody tells me they inspect my property, I would know that. We own it. I would see them. They would be there. I don't give people permission to inspect my property without my permission. But yet they found certain things that were wrong with the rental. How's that possible if there was no inspection? So again,
I think I understand. I've read this, and I just want to make sure, you're giving me this Exhibit 3 to say that you were grandfathered into being able to use your property as a rental. Is that correct?
Well, we've always used it as a rental, so it's always been deemed a rental since.
And it's always been in the R1 zoning, correct?
That's correct.
All right, so that hasn't changed, because as I read this, it says current R1 zoning requires that rentals be no less than 6 months in length. I'm trying to understand your argument. Is your argument that you were grandfathered into something
So if you
less
look
than
at.
6 months?
Correct. Now, if you look at, now, you said current. Now, current is a big word. Current means today's standards, what we live by and what the law is applied to. That's current. If property was purchased after 2006, okay, which we had it before 2006. So we had this as a rental prior to 2006. And I brought in, again, all my licenses showing, I've even got my, our tax return.
Again, I'm not disputing that
Yeah,
you
so
were
that-
operating as a
my
short.
argument is
Hold
this
on, sir,
document-
let me finish my question. My only question is, what part of this document do you want me to look to say that your property being in an R1 zoning was grandfathered into something less than 6 months for a short-term rental? That's just what I'm trying to make sure I don't overlook that language. And I'm going to ask Mr. Trask the same question after I ask you.
Okay, from what I understood, and again, I'm just going to say, however, it says zoning districts, if the short-term rentals were legally operating prior, which is ordinance 1069 on February 28, 2006. So that little excerpt there is what leads me to believe if I had a rental license, which I did, that I should be able to, based on the criteria that you're providing me, and I did bring this down here to solidify whether I'm wrong or right. So I didn't just turn my head and say, oh, I'm right, they're wrong. It wasn't like that. I came down, I renewed my license, I brought and spoke to Mr. Moran or whatever his other deputy's name is, very nice guy, like I said, and his idea to me, he goes, you look right. That's what he said. He goes, I would bring this down, and here we are. At the end of the day, like I said, I have a 6-month lease in place. We are doing some very extreme renovations, so it's not going to be a short term. And unfortunately, this is where we're at right now. So I'm looking for flexibility, I'm looking for leniency, and at the same time, I'm going to give you what you asked for, which is whether you grant me a short term or not, I'm going to live by what my neighbors want. Because ultimately, that's more important than just a couple little things here.
I understand your arguments, and I've read Exhibit 3. Mr. Trask, do you have any questions?
No questions. I'd just like to make an argument.
Sure. All right, and I'm going to give you that opportunity in just a moment, Mr. Trask. All right, sir, is there anything else you want to share with me? Any other documents or any other witnesses you'd like to call?
Just, I'd like to hear his argument.
All right, thank you, sir. Okay, Ms. Trask, I think you heard the questions I was asking, and it's my understanding that the representative, the respondent, is trying to get me to read Exhibit 3 as saying that that property or the property in question was somehow grandfathered in to be allowed to be a short-term rental for less than 6 months, and I don't necessarily read this document that way. But, sir, can you enlighten me on the city's position on that issue?
So, first of all, I remember the letter being prepared and written back in the day when that was actually done. And the purpose of the letter was just to let the public know that it's very important to know that if you didn't have a short-term rental property, that you cannot have one now. And it was basically a notice given to every property owner in Madeira Beach. It did nothing more than say, here is what the code currently reads. As for the grandfathering aspect, that letter did not grandfather that property. That property has to be grandfathered with sufficient enough evidence to show that there were leases in place, there were agreements in place, there was affidavits that would reflect that it was rented on a short-term basis. Whatever documentation that they could do to show that it was it was a short-term rental property prior to 2006, the city would consider it as being grandfathered. But it doesn't stop there. Pursuant to this code section that I've had Mr. Pinkert put up on the screen, it specifically provides that these legal non-conforming uses, which that's what that would be lost after a 365-day cessation of that particular use. So that particular use, even if it was in place prior to 2006, pursuant to Mr. Astorita's own testimony, there were no short-term rentals from 2019, 2020, 2021. So there were 3 years, not just one, but 3 years that the property was not used as a short-term rental. Therefore, that legal non-conforming use stopped. Now, I don't know what had happened prior to 2018, But we know, at least from the testimony that you've heard today, it was not occurring in those 3 years. Therefore, the grandfathering status that he's arguing is no longer in existence, even as of 2020. So with that all being said, I'd like to make a closing relative to the case itself. Can I do that now?
Yes, please go ahead,
Okay.
Mr. Asp.
So it is clear from the testimony that you've heard today that the property was found in violation before a citation was issued, and Mr. Astorita testified that he paid that. There is documentary evidence in the packet that was received into evidence that there was a guilty finding in the clerk of the court records, that being the first instance. Under Florida statute 162.04 it defines a repeat violation as, repeat violation means a violation of a provision of a code or ordinance by a person who has been previously found through a code enforcement board or any other quasi-judicial or judicial process to have violated or who was admitted violating the same provision within 5 years prior to the violation, notwithstanding the violations occur at different locations. So under the statute, the notice of violation that was issued in March and was what we're hearing today would be considered a repeat violation. We think that the testimony and evidence has shown that there is a violation of 110-176 from the body cam language or testimony you heard there and the testimony of the deputy that the property was rented from March 1st, 2023 through March 31st, 2023. Under the statute, though, a repeat violation can be found from the date of the inspection. We know that the inspection was March 9th. So we're asking for you to find a violation of this particular code section, 110-176, from March 9th through March 31st, which consists of 22 days. We also know that under the statute, 162, I think it's .09, it provides that under repeat violations, you as the special magistrate have the ability to fine the property owner up to $500 a day for each day that it remains in non-compliance. We're not asking for that. We're asking that you find that the property was in violation for 22 days at $250 a day, which is half. $22 or 22 days times $250 a day works out to $5,500. That $5,500 is exactly what the tenant said that they paid to rent the property that period of time. So it's not necessarily punishing the property owner for doing this, but it's making it clear that they are not going to violate the code and make a profit on it. We don't want this to be a business decision that they'll rent it for whatever they can, and when they get caught, then they'll argue that, you know, it's just a part of doing business. Make $5,500, maybe pay a couple of $1,000s, and I made a couple of thousand in my pocket. We don't want this to be a business decision. So that's the basis of the testimony showing there was a violation, was in violation for 22 days, and that's our argument to ask you to issue a fine of $250 a day for those 22 days.
Am I allowed to rebuttal?
Give me 1 second, sir. I have a couple questions of Mr. Trask. So what's the city's position? I think the city's position is he's presently
In
in
compliance.
compliance.
Yes.
Even then, so the city accepts the representation that the current person is not a short-term renter, that they're,
If we find out later on that it is a short-term rental, we'll bring another case.
Okay.
But at this time, we believe he was in compliance as of March 31st.
got it.
Yeah.
All right, sir,
So again.
go ahead. I'll listen
I'm
to,
just gonna
normally
take-
I let the city have the last words and say
Well,
have the
the
burden of
last
proof.
statement
Hold on,
is
hold on.
imperative.
Let me just get what I need to say on the record first.
Absolutely.
Normally I give the city the last word because they have the burden of proof. But sir, in this instance, I'm going to go ahead and let you tell me anything else you want to tell me.
Well, I agree on a lot of things that were just said. The one thing I don't agree on is the fact that my expenses are what they are, and money and dollars, it wasn't about that at all. As a matter of fact, I actually did try to cancel that particular situation, and because of who they were and their ages, they had nowhere else to go, and honestly, that's the only reason why that particular month went through. You're not including expenses that we do incur, which are very expensive to have that particular property in terms of just electrical. lawns, all the maintenance there. So to think that $5,500 is a reasonable number, I just have to completely disagree with that. And I think furthermore, when I came into this facility and did speak to the woman who is in charge specifically of these problems, this is not very hard to determine, like when you guys pulled this up to say, hey, Dominic, look, this is where you don't qualify. Had I got that information back then when I myself came down here to ask those questions and to provide the documentation that I thought was necessary, we wouldn't be here. And so, it'd be different, and I would agree with him if I was hiding around the corner trying to make a quick buck from Mary, Paul, and John, but that wasn't the case. I did come down here to try to make sure that, A, I knew where I stood, and B, what legally we could do. So to say that I was violating in terms of a monetary value and the value that he's coming up with, I just disagree with that. And again, I think that had I gotten the answers we've got today when I did bring in this myself, we wouldn't be having this conversation. And if it wasn't for the fact that the couple that was there when I got violated in March had booked prior and would have had a place to go, I would have absolutely canceled that. So I can't tell you that I didn't do it because it wasn't the right thing for me to do. It had nothing to do with money. The $5,500, again, if you want to look at minus my expenses and fine me, that's probably something that I would think is a little bit more in par. But to say because I made 55, I should be fined 55, I just don't agree with that. And furthermore, like I said, I did bring this document in, and all she would have had to say, hey, Mr. Astorita, under Section D, you just don't qualify for that. That's something that would have been fair for me, and again, it would have changed this whole entire quasi that we're dealing with right now because it would not exist. And I think that, again, the gentleman who originally had, whatever the form was that he filed, he was here by himself. I didn't have to beg him. I didn't have to buy him lunch. So I think that says a lot about who we are and in terms of neighbors, what we've done and what we're willing to make sure it doesn't happen again. Because according to what I just heard, we're not going to be grandfathered in. And I'm 100% okay with that. I think what I'd like to walk out of here is just feeling like, this was fair, and I believe for the most part it has been. But at the same time, I think that, if this situation hadn't come up and I was able to get definitive answers from the city before, this would have never happened. So that's just in my defense.
Thank you, sir, and I appreciate that, and I did listen very carefully to everything you said.
And my last thing would be I would petition the court for a reduction of fine.
Okay. Sir, here's what I'm going to find. I do find the property is in violation of only Section 110-176. That's all the city has asked me to find, and I have listened to what you've testified to, and I've seen that you have the appropriate licenses. In regard to the issue of grandfathering, I've considered what you said about whether or not whether your particular property was grandfathered into some length of time less than 6 months. Based upon the legal arguments that Mr. Trask made, I find as a matter of law that your property was not grandfathered in, so that you cannot lease it for less than 6 months. But sir, I think what the city is asking for, the fact that you have now brought your property into compliance, that's the city's goal for everything. So I'm gonna lessen the amount of the fine the city's asked for. I'm gonna do $150 a day for 22 days.
Thank you.
And I'll enter that order. And again, it's only the violation of 110-176, and it's only for those 22 days between March 9th and March 31st at 150 day. And I will send that order out, and then you can work with the city on anything else you need to work with the city.
No, I appreciate that. And like I said, I appreciate it. And just, can I talk to the sheriff real quick too?
Well, I tell you what, we're going to go off the record because I believe that's the last bit of
If you show
business,
up
and
anytime you want and knock.
then you can go ahead and talk to the city. Anything else, Mr. Trask, for me?
No, thank you. Appreciate your time.
All
I
right,
appreciate
thank
your
you.
time. Thank you so much, guys.